Well, welcome, and I'd like to thank you for joining us for our webinar today. We appreciate you taking the time during the busy week to join us and learn about why you definitely want to avoid estate litigation. My name is Kara Musa, and I'm the Director of Marketing for the Kopenbarger & Kopenbarger Law Firm. I've been here for over 5 years, and I truly enjoy what we do here. We help so many people, and we work as a team, not only within the firm, but also with our financial advisors and CPAs and other people that are instrumental in protecting your family. We are the Kopenbarger & Kopenbarger Law Firm, and we have been in business for over 40 years. We have 9 attorneys and dozens of support staff that are highly qualified and happy to serve you at any time. We have offices all over the state of California and are able to meet with you in person or through virtual means such as Zoom. In the chat box, I will be adding a link to partner@kopenbarger.com. If at any point during the webinar you decide you need to schedule an appointment to come see us, please click that link and provide us with your first and last name, plus your phone number so we can reach out to you today. Your presenter is Dale Anderson, and he is one of the 9 attorneys within our firm. Dale works in the Estate Administration Department with focus on probate and estate litigation. He works mainly in our Orange County and San Diego offices, but with new Zoom technology, he can meet with anybody, anywhere. Dale is a wonderful attorney who knows the ins and outs of estate planning, probate, and when necessary, estate litigation, and is dedicated to serving every client to the best of his capabilities, both in office or in the courts. Here he is, Dale Anderson, everybody.
Thank you, Carol, and welcome everybody to our live webinar on 3 problems which cause estate litigation. Now, as we get into this topic, I guess the first thing we have to cover is what is your estate? If we're going to talk about estate litigation, we're going to talk about what is your estate, and then we'll talk about what exactly is litigation when we talk about litigation. And then we will get into the problems causing estate litigation that we have come across. And there are 3 main problems. And those are, first off, problems with documents, problems with trustees, and then problems with beneficiaries. And then we will discuss how it is we at Kopenbarger can help you in some of these situations. So first off, I guess we got to begin with the introduction in real basic to estate planning. And many of you may have already been our clients and you already have some of these documents. But just to refresh your recollection, estate planning is basically planning your estate. And I guess we cover first off, what is your estate? And your estate is just about all the toys and everything you've accumulated over the years. And believe it or not, even though some of those toys are things you might not want, once you're gone, kids will fight about those. So as part of that plan and part of avoiding it, there are basically 4 documents that should be a part of everybody's estate plan. First off is the Advanced Healthcare Directive. And that's a document that gives you control over what happens to you when you can no longer make those decisions. It's a legal document signed and valid in California and in most states that states if you can no longer make those healthcare decisions, who makes those decisions for you, and in certain circumstances, what decisions must they make at that time. Another document that's necessary or important to your estate plan is the durable power of attorney. And this is a document by which you name someone to speak on your behalf. Now, in my workshops that I give, I always ask people this question: what is an attorney? Now, in its essence, an attorney is basically someone you name to speak on your behalf. Now, me, for example, I'm an attorney at law, an attorney at law. What does that mean? I speak for you as to legal matters. But you can have an attorney for just about any reason. And so these first 2 documents are documents by which you name an attorney, a person to speak on your behalf. First as to your medical and healthcare decisions, and the next one as to your financial decisions. The next document I want to talk about, a little bit out of order, is the living trust. The living trust, and we like to use this illustration, and if you've been to our seminars, you've probably heard it before. A living trust is like that little red wagons kids used to play with. You know, I think they're called the radio flyer wagons, and they'd put their toys in the wagon, and then they'd pull the wagon along with them and stop and play with it and allow their friends to play with their toys. That wagon is a great illustration of what a trust is. A trust is simply a vehicle by which you hold your toys. Now, while you're alive and well, you're the one pulling the handle of that wagon, right? You're the one that's in control of everything that's in the wagon. Now, on the handle of that wagon is a set of instructions you've set up ahead of time saying, if I drop the handle of this wagon, who picks it up and starts pulling the wagon, and what do they do with everything in the wagon? All right? That's just a real simple illustration of what a trust is. And it's called a living trust because it's created while you are alive. And you give yourself the ability to make changes. If it's a revocable living trust, you're allowed to revoke it and make any changes you want. Now, a pour-over will, what that is, it's a catch-all, it's a safety net to say, if I forgot to put something into my wagon, all the pour-over will says is get everything that's in my name that's outside of the wagon and pour it over into the wagon so that it's controlled by my instructions that I left for the trust. So those are some of the essentials, documents of an estate plan. Now, when you get these documents, now you might get some problems. So what is litigation? You've heard the term, but let me just break down real simple what litigation means. Litigation is simply a process that we use to get assistance in accomplishing, obtaining, protecting, and defending our rights. And that process is a legal process. All right, it means it involves the court. And so it's a process that you use to accomplish your rights, protect your rights, or obtain your rights. It can be something as simple as a sibling rivalry. Now, we always tell people, remember those kids that used to fight over toys when they were little? Well, guess what? They still fight over toys. Unfortunately, the toys may be a little bit more expensive now, but it doesn't have to be. I have seen litigation, family fighting over things as simple as a Dutch oven pot that you would cook spaghetti in. But those sibling rivalries that were always in existence, sometimes they come to the head after mom and dad are gone, because you see, when kids fought over toys when they were little, who was the referee? That's right, mom and dad were the referees. But when mom and dad are no longer there, the judge has to become the referee. And so we have to use the court to be the referee. Now, the problem with the litigation is the costs of litigation. And there are different types of costs. First off is the economic cost, and that's the money. How much it costs in money, dollars and cents, to go through litigation. Now, quite honestly, if something goes into real litigation, the cost can be anywhere from like $30,000 to over $300,000. That's right. Litigation could be anywhere from $30,000 to over $300,000. Now, as you can see, that could take a chunk out of anybody's estate. But there's that economic cost. But even more than the economic cost is the emotional cost. And when I say the emotional cost, it's the destruction of relationships. It's the further fostering of those rivalries. It's those mommy and daddy issues coming to the surface, and those relationships between families that can be further fractured as a result of litigation. And there's also the problem with, even if it's not fracturing your relationship with someone else, it's kids having to live through old wounds, that having the scabs ripped off. So there's the costs of litigation are both economic and emotional. So obviously that's something we want to avoid. So what are some of the main causes with that lead to litigation in estate planning and estate litigation? First off, one of the problems that we will talk about is problems with the documents themselves. Okay. First off, one of the problems is with poorly drafted or worded documents. Now, it used to be years ago that when trust first started, you needed to have a certain level of expertise, and not everybody thought they could do, preparation of trust. However, with the advent of the word processor, now every attorney who has a word processor thinks that they can do estate planning. And so they start with documents and they prepare these documents, but unfortunately they don't understand the concepts of trust. They don't understand why certain words are in the documents. It can lead to problems. And like I say, I've got one right now that's in litigation that an attorney had a document, was preparing it, and when the attorney drafted a document, they prepared a certain paragraph, and it had both siblings in the paragraph talking about what they got and what they could do with what they got. And the attorney later thought, well, that's a little bit confusing. I'm going to break that paragraph apart and create two separate paragraphs. But the problem is when they did that, they didn't realize another section had referred to that section, and she didn't correct that other section, so that now there's litigation over what was intended, and so it can cause a problem. I also have one right now where there's litigation involved in the wording in the document. I had a lady come to me this week. It was a document that was prepared by another attorney, and in the document itself, it said that when the first spouse dies, the trust becomes irrevocable. Okay, well, the surviving spouse then went back to the same attorney and amended the trust and amended a portion of the husband's side, which under the document itself couldn't be done. I actually litigated a case very similar to that a few years ago, where the husband and wife had created a trust that said when the first spouse dies, the trust becomes irrevocable. The wife died first in that case. The husband went back to the same attorney and tried to amend the trust, changing which one of the siblings, or the children got what, who was going to be trustee. Then the father died. And now there was a fight over who's trustee. Was it the trustee stated in the original document, or was it the trustee stated in the amended document, which, according to the document itself, couldn't be amended? As a result, there was a fight, there was litigation, and this is literally, it was over $230,000 in attorney fees just to try and get back to what the document originally said. So one of the causes of estate litigation is poorly drafted or poorly worded documents. Another problem which with the documents that causes litigation would be incomplete documents. And by that I mean that the attorney didn't include everything in there that needed to be in there to complete the wishes of the settlers or the trustors, the people creating the documents. And it couldn't be just in the trust itself, but it's also in making the trust effective. Like I said, maybe they created a wagon, but they didn't do all the documents necessary to put assets into the wagon. And it's not unusual. Sometimes, especially if you go to the low-cost attorney, they'll create the wagon for you, but they won't put anything in there. And people are pulling around an empty wagon. Okay, and that could cause litigation. I had one that was involved in litigation where they had the trust. They listed in the trust document itself that certain assets were divided equally amongst the children. But then they didn't do the next step of actually going to the bank to change how the bank accounts were stated. So although the trust said these certain bank accounts would be divided equally amongst the children, there were incomplete documentation in that they didn't go to the bank because the bank still had what's known as payable on death designation on those accounts. So there was litigation over whether the trust controlled the bank account, and the person who was trustee in that case brought a motion to try and put those bank accounts into the trust, where the people who were the designees on the bank account said, no, these aren't in the trust. So incomplete documentation can lead to litigation over what exactly was intended. Another problem with documents can be that they are out of date. And sometimes the documents that were created perfectly when they were drafted become out of date because the people never come back and have them corrected. Most times, documents get out of date because life itself changes. Not necessarily because the law changes, but because life changes. I had one family come to me. The husband and wife had set up their estate plan. And the husband in the estate plan had said that when he dies, certain items would go to his quote unquote wife. Well, the wife then passed away. the husband then got remarried, never changed the trust, so that when he died, it still said, my wife shall get blank documents. It caused problems between now who were the stepchildren of the spouse, who was going to get certain items. Other things that can happen is that people change. You may name somebody as a trustee in your document who at the time you named them as trustee may have been a great choice for a trustee. But 20 years later, maybe they're not a good choice. Sometimes you put in protections for children, and then you forget about your trust, and 20 years later, those protections are no longer needed, and now you may have issues with the children. And then sometimes the law does in fact change. A classic example of this would have been with the new HIPAA laws that came into effect in 2004. If you had your healthcare power of attorneys that we discussed at the beginning of this drafted before 2004, the moment 2004 hit and the new rules for the HIPAA came into place, all of those healthcare power of attorneys became obsolete, and none of them were worth anything. So sometimes the law does change. And another example would be if you made certain provisions in your documents for your retirement plans. And then with the new Secure Act, maybe the way you had it set up before isn't the best way to set it up now. So out-of-date document can be another cause of estate litigation, as the beneficiaries fight over what exactly is meant and what should be stated. Another problem, in addition to problems with documents, is problems with trustees. Sometimes it's the trustee themselves who are the problems. First off is the absent trustee. All right, I had a case where the person who set up the trust had named one of their children as the trustee. Mom was the one who passed away, and when mom passed away, the trustee didn't want to stick around, and so ended up moving out of state and wasn't doing anything. All right. In fact, I had another one come in not too long ago where the husband and wife had both passed away, and the person named as the initial successor trustee had moved away and was living in Colorado, I believe it was. So sometimes there's an absent trustee, physically absent. But there's also trustees that can be absent just mentally. And I mean, and by that, I mean, they're just really not up to the task. They're not doing anything. When the trustee who was set up by the parents or whomever set up the trust just doesn't do their job. They're just completely, they're absent. That leads to estate litigation. And I've actually been involved in litigation trying to either remove the trustee and name the next successor, or have the court order the trustee to actually do their job. So an absent trustee is a problem that frequently causes litigation in our experience. Another problem with trustees that sometimes leads to litigation is what we call the tyrannical trustee. And maybe you know them. They're the person that we like to call them the because I said so trustee. And those of you watching, if you're a parent or ever had parents, you've probably at some point said or heard in response to a question, well, why should I do that? What's the answer? Because I said so. And many times trustees take that position that, hey, they're named as trustee. And frequently in the trust documents themselves, it says the trustee can take certain actions in their sole and absolute discretion. And so a trustee may read that and seeing sole and absolute discretion and think they have the right to do whatever they want. I had one that was involved in litigation where that's the position the trustee took. That the trust had said they have sole and absolute discretion on how to handle certain assets and how to make distributions. And they took that quote unquote sole and absolute discretion to mean they could do whatever they wanted and they didn't have to give any reason to the beneficiaries why not. So I had a couple of the beneficiaries come to me and complain. I said, well, just because the document says quote unquote sole and absolute discretion doesn't mean they can do whatever they want. Because the probate code specifically states that when a trustee is given quote unquote sole and absolute discretion, that discretion still has to be exercised within the bounds of fiduciary principles and the terms of the trust. So the trustee still has to follow what the trust says and what the law says, even though they were given quote unquote sole and absolute discretion. But the tyrannical trustee, the one who just does whatever they want and thinks they don't have to report to the beneficiary, that can lead to litigation and unfortunately all of the costs that are associated with it. And then next, my problem with the trustee is maybe they're wanting to be trustee. Maybe they're not being tyrannical, but they just not up to the task. Because we tell people, you know, just because that child is the oldest doesn't mean they make the best trustee. Sometimes the oldest child is the worst choice for a trustee. And it's not to say anything against them that they're dishonest or that they're tyrannical. No, some people just are not up to the task of being a trustee. Because you see, a trustee is not an honorary position. A trustee has certain duties and obligations under the trust and under the laws of the state of California. And when the trustee fails to live up to those duties, either under the trust or under the probate code, that can lead to problems, and the beneficiaries are left with no obligation or alternative but to commence litigation. All right, so what are some of the requirements of the trustee? These are certain tasks that are all involved in an estate administration. If the trust owns any land, any real estate, those land records have to be updated. Because if the trust owns real estate, it's owned in the name of the trustees. So let's say John and Mary Smith own some real estate, and they set up the John and Mary Smith Revocable Living Trust. They then want to put their house into the trust, excuse me. So the way they do that is they transferred a deed from John and Mary Smith to John and Mary Smith, trustees of the John and Mary Smith Revocable Living Trust. All right, so now John and Mary Smith are deceased, and son A is now trustee. Somehow he has to get that real estate out of the name of John and Mary Smith trustees into son A's name as trustee. So you have to update the land records. Now, when you update the land records in California, many of you are familiar with Prop 13, which limits the county assessor's ability to reassess the property except under certain circumstances. And one of those is when there's a change of beneficial ownership. So once the trustee updates the land record to show him as the trustee, that will trigger the assessor's office to say, aha, we can go out and reassess the property. If, however, that property is going directly to the children of the trustees, that's one of the exceptions to Prop 13. So the county assessor has to be notified that this is not an assessable event, okay? That these are all duties of the trustee. Next, under the probate code states that whenever any trust or any portion of a trust becomes irrevocable, notice has to go to all beneficiaries and heirs, notifying them of the fact that the trust is now irrevocable and that they have a right to a copy of that irrevocable portion. Now notice it says notice goes to all beneficiaries and heirs. Now what's the difference between a beneficiary and an heir? A beneficiary is very simple. Who's named in the document to benefit from it? Who does the trust itself say are the beneficiaries? An heir is a little bit different. Sometimes they're the same, sometimes they're different. An heir is simply this. I always tell people, whether you go to an attorney or write it yourself or do nothing at all, everybody has an estate plan. All right? Because if you don't take care of it yourself and write one yourself, the state of California has written one for you. And we in the legal world call that the laws of intestate succession. You've probably heard of last will and testament, right? Intestate means without that testament. So if you die without any statement as to what you want to happen with your estate, the state of California says what happens to it. So an heir is who are the beneficiaries under the state of California's estate plan. Now, remember, and don't get confused, that you have the right to name what happens to your estate. What the state of California says is only if you don't do that. But in the case of a trust, when someone dies, the state of California says we want our heirs notified so that they have a right to challenge the trust if they were left out. Because we've got many people who maybe have 5 kids, but let's say the middle child was a drain during lifetime. So at death, mom and dad said, you know what, child C got their money while they were living. We're going to give what we have on our death to the other children. So they cut them out of the trust, not because they don't love them, but because they already got it. In that case, child C would be an heir, but not a beneficiary. Okay? But the probate code says notice goes to all beneficiaries and heirs. All right. Next thing that would be part of the duties of the trustee would be to notify the California Department of Health Care Services, notifying them of the fact that the person has deceased. And that's quite simply, that's who runs Medi-Cal in California. All right. And what the Department of Health Care Services does is they search their records and say, have we made any payments on behalf of this individual? Because if so, they want to file a lien against that deceased person's estate. So one of the things the trustee does is has to notify them so that the state of California, Department of Health Care Services will write back saying, we've searched our records and we cannot find any payments and we have no claim at this point. Another thing the probate code requires is that within 30 days of a person's passing, it says the custodian of the original will. In other words, the person who has physical possession of the original will. We're not talking about a copy of the original. We're talking about the portion, that will that was actually signed, what frequently is referred to as the wedding copy, the one that was actually signed. Whoever has that is supposed to file that in court where probate would take place within 30 days of a person's passing. Now again, that's not starting probate. It's what we call filing it for safekeeping. Because as we're discussing right now, sometimes in the administration process, rivalries happen, disputes happen. So the idea behind the law was, let's get that original will into court as fast as possible before, you know, Johnny and Mary start fighting over, well, I wanted that and you wanted that and mom wanted me to have that. Because one of the ways of revoking a will was simply to rip it up. One of the ways of changing a will was simply they would line out a person's name and initial it. So the idea behind the legislatures requiring this real short time to get the will into court is before all of those rivalries arise, get it into court and we'll keep it. The clerk of the county will keep it safely from being destroyed or ripped up. Now, I also quickly tell people there's no such thing as a will police. There's nobody sitting at the courthouse and saying, all right, 31 days, where's that will? But the probate code says if you do not file it within 30 days and someone is damaged by that, you could be personally liable. But that's part of the requirements of your administrator once you name someone. Next thing they need to do is obtain a new taxpayer identification number. While you're alive and you've got your estate plan going and your trust going, you're using your Social Security numbers as the tax number. However, Social Security numbers die with the individual. So now that the trust is there, the trustee will have to get a new tax number for the trust itself because the trust is now the entity. And the trustee may, in relation to that, have to file a fiduciary tax return. You've heard of 1040s are the individual's tax return. A 1041 is the tax return for the trust itself. And when a trust generates income, be it from interest at a bank or dividends from stocks or bonds, income itself, that income has to be recognized by someone. So, and a fiduciary return has to be prepared so that all of the beneficiaries can know which portion of that income was theirs, so they can report it on their personal income tax return. And they would need to therefore notify both the IRS and the Franchise Tax Board that they are now representing and will be signing the tax returns for the decedent. That leads us into what is part of the trustee's duties as far as taxes, the personal income tax returns. For example, if someone were to die July 1st of this year, 2020, that means they still have earned income for that first 6 months of 2020. So by April 15th of next year, that final personal income tax return will have to be filed. And sometimes that becomes an issue. And one of the cases I was litigating, the issue of the tax returns became very important. Were they filed? What was claimed on the tax return? What kind of deductions were claimed? All of that becomes very important as a trustee duties. Part of it is the estate tax return. Is there an estate tax? What is in the estate? What is included in the estate to determine whether there is an estate tax return even required? All right, sometimes when one spouse dies first, the surviving spouse has the option of what they call estate tax portability election. Most of you know this, maybe some of you don't. At this point, each one of us, if we were to die this year, each one of us can leave $11.5 million. All right, if you're like me, you don't have the $11.5 million to leave, but you can leave that $11.5 million without incurring an estate tax. All right, so what happens when a husband dies first and his half of the estate is less than $11.5 million? What happens to his $11.5 million he could leave? Well, it used to be that it would just kind of evaporate and go away. Now the surviving spouse can actually reach over and grab that unused portion of that $11.5 million and pull it over to their side. And that's what we call the portability. They can port that unused portion over to their side to have, so that they can leave extra money in case they won the lotto. Or we tell people, what's the problem with that $11.5 million number? Exactly, what's happening in a couple of weeks? We're gonna have an election. And depending on the results of that election, that $11.5 million number may disappear or go down, drastically down. So exercising the rights under the estate tax portability election, a spouse can put in their pocket some money to use in the future. Income tax basis, the trustee would need to prepare what we call an inventory of assets. And this is one of the most important documents in the administration process, because what the inventory of assets is, it's basically what it sounds like. An inventory of all the assets that are in the quote-unquote wagon or the estate. And then it gives the date of death values for each of those items. That becomes important for a couple of reasons. First off, it establishes a new tax basis for that item. Now, I'm going to give you a real base education on what tax basis means. It's basically the baseline. If something goes above that baseline, you have capital gains. If it goes below that baseline, it's capital loss. And for most things, that baseline is what was paid for. So I've had people who've come in and they bought their house back in 1960, and I just had somebody tell me this. They bought their house in 1960 and paid $17,000 for it. Okay, actually mom and dad did. Mom and dad are now died, and now the house is worth over $600,000, right? That difference between $17,000 and $600,000, if they had sold it the day before mom died, they would have had a capital gains on that difference, right? But now that mom died, the baseline, the basis is now what was it worth as of mom's date of death. So that inventory of assets becomes very important for establishing the property tax basis. So hopefully you can begin to see there's lots of issues that a trustee has to deal with. In any one of these, they can stumble. And this could be a cause of litigation, as some of the beneficiaries are trying to force them to do their job. All right, next, the third problem with litigation. We've already talked about problem with the documents. We talked about problem with trustees. But the third problem is problem with the beneficiaries themselves. All right. Many beneficiaries are just plain old impatient. You know, mom died 2 weeks ago. Where's my money? That kind of thing. What's the trustee doing? They're just impatient. Some of them are. Another problem with beneficiaries is they're unthankful and they just simply want more. I don't care what mom and dad gave me. I don't care that they divided everything equally. And I actually had a case involving a dispute with the beneficiaries, in that there were 5 kids, and mom and dad's trust said that the estate would be divided equally between the 5, so that each one would get, what, 20%. Well, one of the beneficiaries said, well, I don't think that I took care of mom and dad during their last. I've always lived with them. I should have 40%. Those can be problems. I had a case where an uncle had passed away. A man died. He had a live-in girlfriend, but he had no kids, no spouse, but he did have a couple of nephews. All right, and the nephews were given a small percentage, I think 5% each. Well, they didn't like the fact that he left most of his estate to his live-in girlfriend, and so, of course, they sued. Now, it took a while because they went through 3 attorneys before they could actually find an attorney who would actually file the lawsuit. But they did. They filed the lawsuit, and because it became so expensive, eventually the trustee and the lady had to settle with him. But that's one of the problems that cause litigation, is problems with the beneficiaries. And again, as we discussed briefly before, some of the actual causes of the litigation are unresolved conflicts between siblings. Maybe they just plain old don't get along. And as a result, just because one sibling gets one thing, the other one wants it. There's just a problem with it. I actually have a case right now that we're dealing with, that the mom and dad had they had 3 kids, and one of them needed a special needs trust, so they put some aside for that child. But then the other 2, one of them had always made bad choices in their lifetime, bad choices with their partner, bad choices with finances. But the other one was accomplished and made good choices. So what they decided was, rather than just give the money to the one that's always making bad choices, well, we're going to give it to them in trust. So that it would be protected from their creditors, protected from bad people. So both of the children got their money in trust, not directly in trust, but the parents named the good one as trustee of both trusts, not only of their trust, but of the one who had always made bad choices. Of course, that just when mom and dad died, that rivalry between the siblings just sprang to life again, and we've been litigating for a couple of years. So beneficiaries can actually be the problems causing the litigation that we go through. But these are some of the common concerns of beneficiaries that may lead to it: lack of communication, the trustee just not communicating with them. And I always use this illustration. Many of you, if you've flown on an airplane and you ever gotten on the airplane and you're all seated and you're ready to take off, and they push you away from the gate, and all of a sudden then you sit, and you sit. You get really impatient, don't you? But on some of those occasions, when the captain gets on the radio and says, oh, we've got a problem, it should be fixed, and he just keeps you updated, the waiting isn't quite as bad. But if they never tell you what's going on, people could get very impatient. And the same is true with beneficiaries. During this process of administering the estate, if the trustee keeps them updated, keeps them informed of what's going on, that can ease a lot of the problems. But some of the problem arises because the trustee just doesn't keep them updated on what's going on. Then there's some of the problem is the delay. Now, some of the delays are inevitable because there are certain steps that have to take place. There are certain things that require certain notices, but there's delay. But from the beneficiary's point of view, 4 months have passed since mom and dad, or mom or dad died and the last one died. Where's my money? Well, the reality is it may take a lot longer than that to get all the notices out, to deal with real estate, etc. But the delay. So some of them beneficiaries get impatient with delays. The perception of favoritism, allowing one beneficiary to benefit from the assets more than the others. That can be a problem. As we already discussed, the perception of the tyrannical trustee, because I'm the boss, because I said so. Lack of communication with the attorney. And in this we mean, sometimes the beneficiaries will say, well, mom's always told me that I was going to get this. Well, mom maybe told you that, but mom may not have told the attorney that when they did the estate plan. So sometimes a lack of communication from the settlers to the attorney may have caused some of the problems. And sometimes, you know, the settler themselves, the person who created the trust, may not have followed through to set up the estate plan the way they had intended to and had told their children or beneficiary they were going to. So that beneficiaries who were told they were going to receive something never receive it. And sometimes part of the problem causes that beneficiaries' concerns is that they don't have a copy of the trust itself. A lot of them just want to see, what does it actually say? Now, as I told you earlier, part of the notice that goes to the beneficiaries from the trustee is a notice that they actually have a right to a copy of the trust. So when they don't get it, some of them feel put out, and it may lead to litigation. So you see, there are different problems with the beneficiaries that also can lead to litigation. All right, who do we represent in all this process? Well, first off, we'll start with the beneficiaries. As I told you, as we went through this, some of the people we represent are beneficiaries because the trustees are not following through on their duties, or they're just not doing what they're told. I've got one right now out of the Los Angeles County Superior Court, where it's one of the beneficiaries that has to bring litigation against his brother, who was a trustee, because many of these reasons we just talked about. Because the brother wasn't talking to him, wasn't keeping him updated, was shunning him, so that now the beneficiary felt disrespected. So we represent beneficiaries in making sure that the trustee is doing their job right. Then we also represent the trustees to help keep a lot of these problems from happening. We represent trustees when they are sued by beneficiaries. If the trustee comes to us for the administration process and the beneficiary just doesn't like it, and they sue the trustee, we represent trustees in defending it against the claims brought by the beneficiaries themselves. All right, how can we help? We can help determine who are the proper trustees. And when you're doing the estate planning process, we can help you, one, pick the right trustees in the plan, and then once people have passed away, we help read the documents to say who is the trustee. We can help handle asset disputes. If there's fights over which assets are in the trust or not in the trust, or what asset goes where, we can provide some guidance to the trustee on the investment of assets and handling of the trust assets. We've also represented and filed actions to try and get a trustee removed who was not doing their job. Sometimes we've also brought actions to help get assets into the trust. We've had a few times where people will put their primary residence into the trust. And this is a common problem that we have seen. They then want to refinance that house. And for some reason, the mortgage company says, well, we're not going to refinance it if it's in the name of the trust. You have to take it out of the trust and put it into your name, your private name. So they do that to get the mortgage, and then they forget to put it back in the trust. So they forgot certain assets. Or they intended to put certain assets in the trust, and they list them on their schedule of assets that they intend to be in the trust, but they don't take that next step of actually going to the bank or going to the financial advisor and transferring those assets into the trust. So we can do that. We can go to court on a motion, what we call a Hagstad motion, to get the assets that were intended to be in the trust that were somehow inadvertently omitted and get them back into the trust. We've also handled what we call undue influence claims, both somebody being sued claiming that the trust is invalid because it was procured by undue influence, or representing the beneficiary suing somebody else claiming undue influence. In fact, I'm working on one of those right now, where someone who's a caregiver of the decedent had made this will and had told everybody when he died, he wanted everything going to his nephews, that when he died, the nephews it was gonna be all their assets and all their problems. Then he got ill and he brought in this caregiver, and the caregiver worked on him until he finally just signed over the house to the caregiver. We are bringing an action under undue influence to try and get that undone. So that's kind of some of the things that we've handled. All right, but I've also handled some with the trustee where I had another one where one family member lived up in the San Jose area, another family member lived in Irvine area. When mom was living with the person in San Jose area, that person in San Jose was named power of attorney, was named on the accounts, everything. But then when mom would go and visit the child in Irvine area, guess what? Everything got changed. The person in Irvine was named as the power of attorney. The person in Irvine was getting everything in the trust. So those are some of the undue influence claims that have actually arisen in our practice and that we have handled. Here's other types of litigation that we either handle ourselves or we partner with other attorneys. Because I've been an attorney for 35 years, and most of that has been in litigation, as well as the estate planning area. And so I have developed relationships with different attorneys who sometimes assist us, or we partner with, or we refer to in different areas. Some of them are contract disputes. Elder abuse cases. I've got a case right now in litigation involving elder abuse and wrongful death. Certain personal injury cases that we either handle ourselves or partner with others in handling. So if you think you have some litigation either in the estate planning world or others, like the contracts or personal injuries, just give us a call and we can either help you ourselves or make sure we get another attorney that we work closely with to help you. All right, so in review, these are the three problems that we have causing estate litigation. Remember, problems with the documents. Sometimes the documents themselves were poorly drafted or not kept up to date, which leads to litigation problems. So we can get the court to interpret those documents and tell us exactly what they mean. Then also the problems with the trustees. Remember the different areas of the trustee that we can have problems with, be it they're absent, or be it they're tyrannical because I said so, or because they're just incompetent. And then problems with the beneficiaries. Sometimes the beneficiaries themselves have their problems, and we represent the trustees in taking care of those. So those are the three main problems causing litigation. And with that, I will turn it back over to Kara.
Thank you, Dale. That was a lot of really useful information. As previously mentioned, Copenbarger Law Firm has been in business for over 40 years. We have 8 full-time attorneys and 1 of-counsel attorney, along with 35 support staff members that are here to serve your every need. We also have offices all over the state of California, 7 to be exact, and can meet with you in person or through virtual means such as Zoom. Our team will be sending out an email with a recorded webinar soon so you can share this valuable information with your family and friends. As Dale stated, it's extremely important to have proper estate planning in place so you don't have to deal with the hassle and high costs of estate litigation. Because you tuned in today, you are eligible for a complimentary consultation with one of our attorneys. Whether you need to establish an estate plan for the first time or need to review your existing estate plan, your consultation is completely free. Remember, we are here to help you through all stages of your life and appreciate being your expert referral for all your professional needs. We look forward to serving you and your family for many years to come. Thank you so much, and I hope you have a wonderful day. Bye-bye.